We're going to do the subcommittee.
You can see it?
No, yeah.
Okay.
Alright. Let me do the, just text her.
Would the subcommittee judiciary seat please come to order? Subcommittee will come to order. The clerk will take a silent roll call to determine the presence of one. Yes, presence. Quorum being present, the first item on the agenda is approval from our previous meeting. Chair recognizes the vice chair.
Mr. Chairman, I move that the minutes from the previous meeting be approved.
Is there discussion? Are there any amendments to the meeting? Are there any amendments to the minutes? If not, the question on the motion is to approve the minutes from the previous meeting. All those in favor will say aye.
Aye.
Those opposed, no. In the opinion of the chair, the ayes have it. Declare the motion. The minutes is approved. Next item on the agenda is committee substitute for Senate Bill 42. Council, would you please explain the committee substitute?
Thank you, Mr. Chairman. The subcommittee has before the committee substitute for Senate Bill 42. It would amend and reenact a number of sections in Article 2 of Chapter 4, specifically sections 12 through 16 and sections 18 and 21 of that article. Current law requires that interest in condemnation proceedings, which are civil proceedings, be paid at the statutorily fixed rate of 10%. The committee substitute would make the interest rate for those proceedings the same as the interest rate established by the State Supreme Court's administrative office for judgment decrees entered in that calendar year. For 2023, that interest rate is 7%. As an aside, in 2022, it was 4%. The committee substitute further sets a 7% floor and a 9% ceiling on the interest rate. That is, the interest rate for condemnation proceedings would never be below 7% or above 9%. If this were to become law, the new rate would only apply to condemnation proceedings instituted after the effective date of the legislation. Condemnation proceedings instituted prior to the effective date would remain under the current 10% statutory interest rate. The committee substitute differs from the introduced version insofar as it sets a minimum interest rate of 7% and a ceiling of 9%. The introduced version simply incorporated by reference the Supreme Court's judgment interest rate. It could be below 7%, it just so happens to be at 7% right now in 2023. The committee substitute also makes some technical changes, and those changes were discussed with Council for West Virginia DOT, who's present today, and Nathan.
Are there questions of council?
Yes.
Senator from Jefferson.
Thank you, Council. Thank you for explaining that. So this is not something I'm very familiar with. Could you explain under what circumstances this would apply?
So, for example, if the highways wanted someone's land to build a road, and they could not agree on what is the fair market value, and they went to court. And Nate's here to help me out if I mess this up. But if they went to court, essentially the department would deposit what it believes the fair market value to be, or the commissioner determined the fair market value to be, into the court, which is then available to the landowner. If it is ultimately determined that there was a difference in what they assessed the fair market value to be and what was ultimately decided by the judge or jury to be the fair market value, then you would owe interest on that. The state would owe interest on it. So, for example, if it was fair market value was assessed initially at $100,000, they say it's $120,000. And ultimately the jury agrees with them that it is $120,000. That additional $20,000 would be subject to the 10% statutory interest. I think I said that right.
Okay, so what we're doing is setting it lower, which means less money for the property owner who, but only in those cases where they're getting more, like the court has sided with them and says that they're owed more.
Yes, the senator's correct.
Okay. Thank you.
Are there further questions of council? Would the committee prefer to hear from the Department of Highways or from?
Sure, why not?
State your name.
Nate Connie, General Counsel with West Virginia Department of Foundation.
Solemnly swear to tell the whole truth, nothing but the truth.
Yes, sir.
Maybe question.
Thank you. Should he sit at the table?
Yes.
That'd be
So we can be seen?
Yeah.
better.
Okay.
Yeah, if you like, I can just kind of run through. This was actually an agency built last year. But it eventually went down in the lanes over at houses. That's what we're sitting as an agency. Just by a little bit of way of background, I think, the first perception is that, the state is the boogeyman here, and we come in and we try to lowball the landowner and then, fight with tooth and nail. But that, I do want to stress that that's not the case. We have to follow a federal act called, they just call it the Uniform Act. It's got a fancier name, Uniform Relocation and Assistance Act. And that's a very elaborate process. It's very landowner friendly. And the vast majority of our, particularly what I would call a more simple condemnation case, get resolved because of the benefits of the office. It has relocation assistance. It has, even if someone's in substandard housing, we upgrade the housing. The review process starts with obtaining an appraisal. There is then a subsequent review appraisal of that appraisal, and then a final internal appraisal review to make sure that it's followed all federal standards. And that all goes into determining just the initial just comp amount. And as Mr. Perry alluded, then if we do have to go to the condemnation process or the eminent domain and file a petition, then we would deposit that amount of money in court. The landowner may then immediately withdraw that amount. And really where we see the difficulty, the more complex cases, if there's a business involved, if there's a novel legal theory to be applied for mineral rights or, expert battle over, fair market value, if I lose so many parking spaces or things like that. And those can get drug on for years. And what happens, I think, it becomes an impediment to resolving the matter because, landowners making 10% interest, they can fight a tooth and nail, they've already taken out their initial run. And from our state's interest, we want to get these things done. We prefer not to go to eminent domain. And usually the ones that get protracted out cause problems because that's money we don't know how much we have. The state road fund that may have to go to that. The project could close and it'd still be out there. They call it there's a clean right-of-way certificate where we clear all the right-of-way, and then you have dirty one, and nobody wants to have the one that has loose ends on. So I think that's kind of hopefully a high level. There is a process once the petition is filed. We do gain right of entry, and that's when we do have access to the property, with deedable title or something. There's a land commission process in each county. We have land commissioners who will hear the case and make a recommendation. That doesn't get there. Then it would go to a jury trial. So there's kind of a three-step process in there. And oftentimes I think landowners, this is my understanding, I don't do these cases. A lot of times they want to wait and see and wouldn't ask the court, to put the trial deadline way out so they can see what the whole thing looks like when it's done versus, whatever the plans are. So I kind of just started talking there, but I want to give you guys a kind of a overview of where we're coming from. So, and then the real policy question is, what's a fair amount of interest for the state to pay? for the amendment process. And I have some information from last year. I didn't have a chance today to do any update of it, but we are higher than the surrounding states when they were more in the 5 to 7 range. I think when we did this bill last year, I think we tried to do the cap and the floor, and where the interest rates were much lower. We're trying to do it then. Any questions?
I was going to see if Mr. Hague wanted to testify once we were through.
Well, let's finish up with,
Okay, I just have one quick question. How often does this happen? How often does this happen? That you go to eminent domain to have this?
I mean, that's just a way of life where we are. I mean,
So it is
like if we have a corridor H, there's Lord knows how many parcels through there, and then we're doing this project on the mile ground, this project over here, and they will all.
So it is often.
Yes. We have, a team of several lawyers in-house and then outside firms that we use to handle.
is there further questions? Ms. Witness?
Thank you.
Okay, recognize the Senator.
Thank you, Mr. Chairman. I'd like to hear from Mr. Hague, please.
State your name for the record, and raise your right hand.
My name is Michael Hagan, Executive Director of West Virginia Land and Owners Association.
Do you solemnly swear to tell the whole truth, nothing but the truth, so help you God?
Yes, sir.
Begin.
Michael, who do you represent here today?
It's the West Virginia Land and Owners Association. We represent approximately 3 million acres.
And is it farmers, farmland? Give us a little bit more understanding what your membership and who they are.
Well, they're the large land companies in West Virginia. Beaver Coal, NRP, those sorts of folks, Hardy Resources.
Okay.
Folks like Dickinson's, companies called Golden Crane out of Huntington, you may have heard of. But
Just large corporate landowners in the state?
yeah, but we have some in the state.
Okay.
And we have a lot of our acreage down south, but we have some in the north. We have a lot in Western County and Coast County. Our members are spread throughout.
Okay.
We're not as heavy in the northern counties or the eastern panhandles because the parcels are much smaller. Most of our assets are called timber gas, but we have a lot of real estate tracts and commercial stuff, and it's a mixed bag, but a lot of acreage.
Thank you.
Is there further questions of this witness?
But I'd like to ask the general statements I'd like to make, Mike.
Certainly. Well, let's,
Thank you, Mr. Chairman. Mr. Hague, how would this affect the landowners in the state?
Well, I just want everyone to keep in mind that this interest rate is set high because it's steep. And it encourages the state and the landowner, especially the state, to reach a resolution faster. I mean, after all, the government is taking their land. And I know it's for good use and, represents some other interests and build roads and these things. But you're taking someone's property. So we want to encourage the state to come to the table in good faith, try to reach a resolution quickly, and move forward. And that's what that interest rate does, because these cases take a long time. This whole process takes a long time. It's stressful for the landowner, it's time, it's court costs, it's energy. And now this is a little better deal with the 7% floor and the 9% max. That's better. But, this isn't the end of the world if this bill passed this way, but it comes back to, property rights and being fair to the landowner, because you're taking something that's theirs. It's the government taking it, and that's all. But, it's part of it, and it's part of progress, and we understand that. But, I'm not sure how long the statute has been in place, and this bill has been up. This is at least the 3rd or 4th year I've seen it. So, it comes down to property rights, including property owners there. So that's my only comments.
Thank you, sir, Mr. Chair.
okay.
Thank you, Mr. Chairman. I'm going to play devil's advocate because I think I know where Mr. Conley's coming from on this. It's my first experience with this bill. I hadn't actually even looked at it until I walked in here. So I'm thinking that forever, since I've been a lawyer, interest was at 10% on any verdict, any judgment. It was in law, just across the board. If you won your case, then you got a 10% interest. And I'm thinking back when I bought my first home in 1979 or 1980, my interest rate was 14%, 14.95 actually, on my home mortgage. So we can see we vacillated, obviously over the years. But my question to you, Michael, is this: isn't this just enough, maybe to catch up where we've lowered all the interest rates and made them sensitive to the market, whereas the Supreme Court goes in every year, December 31st, they look at the markets and they set the interest rate within parameters for that year? Isn't that how it works for other judgments, if you know? Okay. So, on one hand, would you agree that we all sympathize with somebody whose property is being taken for a new road? But that was really your argument, wasn't it?
They're taking your property.
Yeah, well, the interest rate has to do with just return on your money. If your client comes out on the good end of it, it's just what are the taxpayers going to pay for that money that they owe that was resolved in your favor, that 20,000 under example. So do you get a windfall, you might say at 10%, where it is now, or you get something that's adjusted to the market conditions, maybe between, at this year, 7%, because interest rates are way down and now up. So do you see the difference? My question is, between the two, yes, they took your property, but you're going to get compensated. And B, what do the taxpayers owe you for the period of time before you got your money? Should it be at a market rate, or should it be at this artificially high 10%? What's your thoughts on that?
Well, I mean, first of all, this, again, my first entry was about Steve, trying to get the deal quicker. And
how would that factor into the interest rate?
well, I mean, the higher the interest rate, it should encourage the government to move faster because it's costing more money.
But that's not the reason for interest, is it? Interest is for loss of use of the money for the period of time you didn't have that money, so you get interest on it. It's from the time that they maybe offer until you presumably got more money.
Right, but the time and the interest rate factor in the total amount that the landowner's getting. Now, the landowner also has expenses trying to defend themselves against these condemnation proceedings. They're hiring attorneys, they're hiring accountants, they're surveying, they're going back and forth trying to figure out, they're looking at comps, they're talking to real estate agents, they're incurring expenses and time and energy trying to substantiate the value that they're getting.
What does that have to do with interest rates?
Somebody's taking your property and you have to defend yourself about the valuations that you get are offered. You're burning money trying to defend oftentimes a value that's under what you think it's worth. That's why you have that indemnity, because you can't reach an agreement. So it takes time, it takes energy, it takes money. So the idea is if the interest rate's higher, it encourages government to move along faster, and it treats us because they're taking our asset.
Thank you.
Are there further questions, Mr. Hay?
One, again, in these court cases, are the costs incurred by the plaintiff? Is it divided up between the two, where they each pay, or is it usual that the party that wins ends up having the costs paid for them?
I think that happens in rare circumstances. I'm not a legal expert, I'm not a lawyer, but I know that a lot of cases our members have been in. We had a complete hire attorney, and the state has their attorneys that are paid by taxpayers, so they have a legal team that I wouldn't call them free because somebody's paying. But we have to hire an attorney.
Okay, but you don't know what, who ends up paying?
Well, I think most of the time we pay for our attorney. And even if we're right, I don't think that the state reimburses us for legal fees that we did find to fight the condemnations. Am I wrong there, Nate?
I think you're correct. The only caveat would be if it was an inverse condemnation case. I think we get stuck with 30 fees. That's a.
Don't even go there.
I'm sorry.
I'm not a the bars in. It's a very complex. I'd like to see you do it, but we don't have 4 hours. Or maybe we do.
Further questions of Mr. Hagan? Hearing none. Thank you, sir.
Thank you.
Is there further discussion?
Mr. Chairman,
Yes.
thank you. With this, I understand the interest in the state to have a condemn the property to lawn and to provide roadways, what have you. But also, my biggest issue is I sympathize with landowners. I grew up on a farm and in different areas. I mean, there's, I-64 went through farmland in our area, and I know it's progress. But I would also, if a family decide to fight Department of Highways or what have you, what other government entity you discuss, I would want that landowner to have be compensated well, especially if they have to draw it out over a long extended period of time. And I know this deals just with the interest rate on the proceedings, but however it may come, but I'm very sympathetic to the landowners at this point in time. I just want to state that I think there's two sides of this. And I know sometimes I'm not a big government kind of guy. I think sometimes we have to make sure that we stand up for the families and the farms that this affects. Thank you, Mr. Chair.
Is there further discussion? Are there any amendments or motions?
So
Senator Judge.
the committee substitute has to be moved, and if we don't move the committee substitute, it goes back to 10%. Is that correct?
Stays at 10%.
It stays at 10%. I just wanted to clarify that. So if I understood the senator from Greenbrier, when you make the motion to move the committee substitute and you wanted it to remain at 10%, you would vote no on that motion.
Correct. I also have a procedural question. If none of us moves the question, I think I know what happens. It dies.
So if no one makes the motion.
If it would die, none of the three of us that are present, can you make the motion?
Pardon me?
Are you, I don't know procedurally, if you could move or one of us has to move.
Well, according to my script, if you vice chair,
Okay.
to move the committee substitute.
Okay.
Well, he doesn't have to. I guess he can. I don't think he has to.
Well, no, I mean, I might be wrong, and you've been here longer than I have.
No.
But in my, I have the suspicion that we still have to follow the procedure and vote
Okay.
it down.
All right. I respect, you've been a chair and I've never been a chair.
Oh,
I'm in the minority party.
well.
I'm still a Democrat.
But you're right.
I've been here since 2015. Yeah. I just look old.
No,
That's what it is.
not it.
Thank you. All right.
Well,
I think the former education chair, the senator from Jefferson, is exactly right, that the motion has to be made. That our council may have a different view.
And if we don't, the committee substitute, we revert back. And then it would be a question of moving the bill as it was submitted. As it was
Introduced for.
Okay. I'm sorry, Mr. Chairman. May I ask a question on the introduced motion?
Sure.
To council? Okay. So the introduced version would be the 10%?
No, so the introduced version would be the West Virginia Supreme Court.
Oh, it's 4%.
Well, no, it's currently at 7%.
Oh, it's going to,
So, but that's just
It would fix it, it would fix
by
it.
chance, it just happens to be at the statute, at the minimum set by the committee substitute.
Okay.
Okay, so if this was 2022, and the interest rate set by the West Virginia Supreme Court was 4%, and we went back to the introduced version, the interest rate of condemnation proceedings, or the introduced version would be passed, would be 4%.
Okay,
So there would be no floor.
I see, I see. Thank you, that's, I wanted to clarify that. And if we were to, just vote to not recommend this bill for passage, what's the current law?
It would go back to as it currently exists, and it would be the 10% statutory rate that's set forth.
Okay. Thank you.
Sure.
Is there further discussion, question?
Mr. Chair, I just want to make sure from council, if we vote this down, it goes back to 10%.
So it stays at 10%, right?
Right,
It's
I know,
currently-
so, yeah, right, it goes back to the way it's written today.
Right.
Okay. Thanks. Thank you, Mr. Chair.
Hearing no amendments, the chair recognizes the vice chair.
Mr. Chairman, I move that we agree to the language of the committee substitute.
The question is on agreeing to the language of the committee substitute. All those in favor will say aye. Those opposed, no.
No.
In opinion of the chair, the noes have it. I declare the motion adopted. It's not adopted. The committee substitute is not agreed to.
So next,
Now I go to the senator from Greenbrier for a motion.
But that wouldn't be correct, sir. Yes.
Yes.
I guess we move to other business then.
well,
I just have to close it.
yeah, so now we're back to the original introduced version, and then the chair then needs to say,
Move the original. Right.
I would just strike the committee substitute language I have in there.
and just use the same language.
Yeah, move the bill.
Yeah, just don't say the committee substitute portion. I guess start at the top again. Then
And then work on and have the vote.
floor.
Including the original bill,
Send it for
not the committee substitute.
So you can have that first paper and start from the beginning again. Instead of saying committee substitute, you say Senate bill. How about that?
Yeah, you are.
Yeah,
Did you Senate Bill 42 for passage? You adopt Senate Bill 42.
But it
The
remains,
chair has to start that.
right, I just want to make sure we revert back to.
We will.
yes.
Right.
42 is the,
The
It is
We
original
have to have a
Senate
vote, we have to have a vote on it, so you.
I see, okay, I'm sorry. And so we have to have a vote on the original bill.
Yes, sir. That's
Okay.
right.
All right. Thank you, sir. Mr. Chairman, I move that the Senate Bill 42 be reported to the committee. I need to go back.
No, that's actually correct.
Is that correct?
Report to the committee.
Committee on Judiciary with a recommendation
And
Keep going.
that it do pass.
Yes, that's right.
You've heard the vice chairman's motion. All those in favor say aye. Opposed, no.
No.
That's in the opinion of the chair, the noes have it. Where the not correct.
Right, so that means that,
Bill does, the bill doesn't, because then
Well-
it's been rejected by the committee.
yes, so when you report to the chair of the judiciary, you will say that the subcommittee voted not recommended.
Then we need other business.
Right. Is there other business to come before the committee? Just a heads up, next Thursday we'll meet again Senate Bill 6, Senate Bill 229, which is dealing with limited liability. We have those on our
Okay.
agenda. With no further business to come before the subcommittee, the chair recognizes the vice chair for a motion.
Mr. Chairman, I move that we adjourn.
The question is on the motion to adjourn. All those in favor say aye.
Aye.
Those opposed, no. In the opinion of the chair, the ayes have it. I declare the meeting adjourned. Thank you.
Thank you.